still on the issue of Abronye, no. There are questions among for ABSA say, okay, see NDC for the argument about Betuja say, this whole issue also Abronye arrest near the no judge no, and I say or pese or use law no, and I say or ye be at the end of the day no, ebema NDC one basem. People said people are now blaming the judge. Me know can say a year Samson Lathy who happen to be news for a host. Or the in Sembia Babe Tuja said, what it in some say, I said this particular person I can answer no. Nipa ya can answer me, can answer me, no. A judge in question or say, oh, ma Abronye bill no. What it will be say, as a judge no, ye consider no for promotion. According to him. What it say, as a judge no, ye consider no for a certain promotion until or no na dream money dear. I didn't all yen or yet. Ne pap or ye ne papi mu anase or ye ejuma sebiu aden de be promoting na bibisa na or the same way ko tuja once again a allegation nti enim if any say consider for promotion and say consider for promotion but then also no I don't think say you saying say ye consider will be for promotion a boni anase nya boni because he can be considered for promotion for various reasons but then ye wa tie in sema a something laddy or the tuja. Because people are questioning say if this particular judge in question or refuse Abronye bill, if it is true for any reason say he is indeed being considered for a promotioner, then any the Brunibeka say I didn't all year no ninsa she bibim what I say obit me cry legend said there's a quid pro quo factor here. It will say Samson Ladi, who is a lawyer. Said the judge who presided over Chairman Abronye's case has applied to get a promotion and has been shortlisted to the High Court. Yes, this is allegations are all. Anyways, but
I'm holding you to just a minute each on the issue about this judge, Samuel Akwa, Bright Akwa, right? Who has been refusing to grant Abronye bail.
Samson, for me, it's not about whether he granted bail or not. I already don't think that this case merited this energy and resources from the state. It could have been done simpler with a clear publication and instruction and warning. But for a judge to write a judgment and suggest in there or state categorically that we are not all equal before the law, that is disturbing.
It says in practice.
In practice. That is the effect of it. The law and the courts is where we can practice that which we are entitled to. That is it. The courts bring finality to what we can access and not access. So if we can go to the court and the courts think that we are all not equal before the law, how do I ever get this constitutional right of mine ever enforced? Where's my hope? We have opened the door to political and elitism abuse. So if you do not have power, you don't count. But this is not the country we sought to build. That the Constitution clearly states from its start, it is we, the people. For God's sake, that judge and the judicial system must take a proper review of his conduct. I don't know the man. I have no personal problem with anybody. You may have legal reasons why you don't think Abronye should have bail. You understand? For example, the argument about flight risk, he has created a legitimacy for it himself. But to pass such comments which are referable, this is judgment. They cannot be the path of our democracy. It can't be the path of our constitutionalism. And it must be condemned by every sound, legal, democratic mind, constitutional mind, legal mind. And I think the Chief Justice should take a particular interest in this matter and review this action. If there's a misconduct on his part, action should be taken. If there's a technical inappropriateness in it, it must be revised. We can't have this sitting anywhere in our judgment because judgment equally become part of our law. Please.
These rulings at the lower court, they don't become part of our law.
So it's from the High Court.
They don't become part of our law.
So when does it become part of our law?
Well, this is a lower court, so it's not referable for any use in any court.
But we can't have some. And you should remember, this is somebody who is supposed to go to the High Court. True or false?
We understand
No, am I
that.
right?
We understand that he applied
Yes.
for promotion because he's qualified to go to the next stage, which is the High Court.
Yes.
And that he has gone through the processes, has been vetted, and is part of a short list of about 12 who will soon
Go to the High Court,
receive their promotion.
to the Superior Court. Can you imagine what is going to happen there if there's orientation of the person going there?
You disagree with his orientation? Yes.
Do you agree?
Exp0se.
You see, when I heard initial comments about what the judge did in court, I was also taken aback. I thought the judge did not rely on any previous decision or had just used his own personal idiosyncrasies. So you know that Carl Lewin has said it, the idiosyncrasies of the judge and not any pretensions of the law. It's actually the law. So when I heard that, I said, but why would the judge? And one writer, Kwesi Boche Jr., has said that the judge did not rely on any authority. So when I read the judgment, the judge relied on his own authority. It can be unethical, but he relied on authority and justified the reliance. He said for consistency. And you know...
Is that how to rely on authority?
Well, that's he relied on it.
He didn't refer to any ratio within the...
He said consistency. He said for consistency.
That in 2024 and in 2020, whatever, he has given...
And then he remanded somebody on, for a similar offense. That's what he said. And that did not raise any hue and cry.
Is that how to rely on authority?
But that's what he said. Okay, so for me, I've been wondering, why didn't Abronye's lawyers go to court ready to repeat the application in the High Court? Because we know that the criminal jurisdiction of the Circuit Court is subject to appeal to the High Court. Why didn't they do that? And if you think that this case is a political case, you should have been prepared.
From what you have read,
yes.
Should he be denied bail?
Well,
from what you have read around the case, should he be denied? I want to move on.
So, and I read the judgment, and he relied on Section 96C and A of the Criminal and Other Offences Act. So that also provides a basis for the exercise of his discretion. Whether his discretion is properly exercised or not.
To cool, as he says, cool tempers. The previous one, that's what he did, to cool tempers. Yes, Miracles.
Well, I mean, Council, my IP is 192.38.1.4.5. Because what I'm going to say, I'm not sure how it will be taken.
You don't need to tell it. We know your phone number.
It's okay. My IP is there. So, Council, I think that the IGP should simply stop what he is doing. As we speak, there's a video of the Buakwa North NDC constituency executive on video saying verbatim that he's going to kill the national organizer of the MPP, Nanabi, the minority leader, Afenyo Marken, and others. He's still walking freely. Don't waste our time with Abronye saying something to bruise.
Do you think he should walk free?
No.
Do you think he should walk free?
Who?
The person you just mentioned.
No, I'm just making a point.
No, I'm asking you, do you think that person should walk free?
If you threaten somebody, there are laws.
Okay.
If you threaten somebody, there are laws, specific laws, that say that if somebody's lives are threatened, they've already petitioned the IGP. He hasn't acted on it. The IGP has a petition, has a complaint from the people who were threatened.
I thought the petition about Azoka and who has also
that
been
one is also
arrested
there.
and granted bail.
Did you ever see Azoka's arrest anywhere?
That's what we are told.
It's okay. Let's stick to this one. So that gentleman is working freely. Yes. The IGP went to Boko. His car was shot at in Boko. He hasn't been able to arrest the people who shot his car. His car, the IGP's car, was shot at in Boko. You know what he told them? I beg you, stop fighting. I promise you police recruitment. He should get serious.
But you know that's a different terrain.
No, please. I beg you. I am only saying that there are more serious, important, critical things to do.
Okay.
Because if you're going to,
it's a minute. We all agreed. The time is gone.
But he used 2 minutes.
I used 2 minutes.
I timed it.
Yes, Bright. Do you think fairly that from the facts you have gleaned, Abronye should not be granted bail?
From the facts I've gleaned, I think he should have been granted bail because I don't think he's in the position to interfere with the kind of investigations they are talking about. And the only really rational basis for denying bail, in my view, if you want to sum up the current practice, would be that you can interfere with investigations. Do you disagree?
That you are also
Or
a
witnesses
flight
or
risk.
temper-
They actually
temper-
quoted this interference with investigation.
Yeah, but I'm saying that given the nature of the investigation you're talking about with NIB involved and the rest of it, I don't see I can interfere with it.
Yeah.
I mean, I just don't see the national.
all right, thank you.
It's very important for your audience. As for the judge, we've all read the thing. Everybody in the country is talking about it. I am sure in the next few weeks, he should get his promotion. Because what he wrote, if it's not for promotion, I don't think any judge will write.
I think the decisional.
Oh, I beg you. Let's be factual.
Oh.
That before this case, as we understand, there was a window for people to get promotion.
Oh,
As we understand, please let's not do this to every situation.
You are sharing information I don't know.
And he was one of the applicants, about 12, who have been shortlisted to get
You're just swallowing
promotion.
the red herring. Okay, throw in the red herring.
Don't do that.
So he's actually awaiting for something.
I'm telling you,
Because otherwise, how do you quote a dictator? Idi Amin in a democratic ruling.
He said Mugabe.
If the man says
It's not
something,
Mugabe, even Mugabe. Is Mugabe an example? A good example?
No, please.